We are delighted to welcome you here to this very special event, a conversation with Justice Sonia Sotomayor. You know, in the life of a law school, there's really nothing more exciting than a visit from a Supreme Court justice. Our students and faculty spend a great deal of time reading opinions and talking about the court. But with all the focus on the court, it's easy to come to think of it as a disembodied thing. A visit by a justice reminds us that it's not disembodied at all. The court is 9 people, flesh and blood people. 9 women and men, each with their own interesting, unique life histories. Of those many life histories, one of the most compelling is that of our guest today, Justice Sonia Sotomayor. Her official biography is in your program, and I won't read it for you here today. But I will observe that that short summary does not begin to capture the full extent of this exceptional jurist and the life she's led. A full introduction would take most of our time this afternoon, so I won't do that. Rather than you're hearing from me, I know you want to hear from her. So please join me in welcoming Supreme Court Justice Sonia Sotomayor. Thank you, Justice.
Thank you. I want to send that beginning to every group I'm going to go speak in front of. People rattle off my background and I go, it's in their book. Thank you.
Thank you so much for joining us and spending so much time with us today. It's such an honor.
I've had so much fun. Your faculty, your students, your administrators, everyone has been delightfully welcoming and really warm. So thank you for the visit.
So I thought we might start off our conversation talking a little about your background. The story of your early life is well known in no small part because of the book you wrote. You grew up in the South Bronx. You were diagnosed with juvenile diabetes at the age of 7 and learned to give yourself insulin injections. Your father died when you were 9 after struggling with alcoholism. It was, in short, a life that was not picket fences and sleepaway summer camp. So you wrote movingly about all of this in your book, and I think the most striking thing to me is the title of the book. The book is not entitled My Struggles or How I Leaned In. The book is entitled My Beloved World. So would you talk about the title and how you came to think of this as your beloved world?
I wrote this book in my first 3.5 years on the Supreme Court. And I wrote most of the writing occurred during the first 3 summers, with editing occurring during the term, the actual term. It was Justice Souter during one of my lunches who said that I obviously used my book to escape the ruminations that every new justice engages in after their first year. And talking to my colleagues, it appears that every new justice at some time at the end of that first term really starts to wonder, why are they there? Why me? And what contributions can I make? What's my role in this enterprise? And it is a time of deep reflection for most justices and one of insecurity for most. It's hard to accept the gift of being on the court without realizing how fortunate you are. But at the same time, being a little scared of it too. It's a big, big responsibility. So I put off that rumination because my entire experience was so big, so overwhelming, that from moments before my nomination, as I was walking out of the East Conference Room in the White House towards the cameras in the front, the president and vice president flanked me. And they have much longer legs than I do. And they were striding forward, and I was sort of hip-hopping. And they were getting really ahead of me. And I whispered, "Please, stop." We're talking about how loud a whisper can be earlier. And they simultaneously turned around and smiled at me. From that moment, I felt as if my conscious self had separated from my body, flew to the sky, and I was looking down at me. I lived like that for about a year and a half. And I explained to people that I'm really not sure that I could have gotten through my nomination speech and all that followed it without sort of separating from that emotion for a period of time. And part of the separation, I'm getting to the book question, part of the separation was my needing to escape from this new life of mine back into my old life. I wanted to hold on to Sonia. I wanted to remain me in this new experience. And to be able to do that, you almost have to identify yourself. And some of it requires, obviously, revisiting and reliving some of the negative. But in the process, I realized of doing that, of retelling my stories into a dictaphone, of going through my life experiences and how I felt, I also began to experience some of the joy in it. A lot of the things, both positive and negative, that I had found strength in and comfort with and a sense of support from. And with the rose-colored glasses that distance can put on moments of pain, it was easier to deal with the pain and to really put it into a realistic perspective of accepting the hardship it caused, but also the strength that grew in me because of it. And so when I actually struggled with the title throughout the 3.5-year process. The title didn't come until I was deep into the redacting with my editor. I had done one draft, and then my editor and I worked on his edits and worked together very closely. And we talked about this process. And he said, why don't you read some poems that I had read in school and see if one of them will inspire something. And I found a Spanish poet who did something not quite realistic for me, because he had relived his longing for Puerto Rico in a very flowery way. But his emotion about the world he had left and longed to return to was my feeling about my world. It really is my beloved world. I treasure every experience I've had in life, good and bad. People will often ask me, what will I redo if I had my choices today? I think maybe only two things. And this is for the many law students in the room. Go clerk for a judge. That's a professional mistake I made, not clerking.
It worked out all right.
Well, clerking will substitute for anywhere from 5 to 10 years of legal experience. You will see more styles of advocacy in the papers you review as a law clerk than you can see in that amount of time in real practice. Because every motion that you're dealing with, every trial that you're involved in, you will see what the advocates are doing, and you'll figure out for yourself what works best and what doesn't work at all. When you see your judge's negative reaction to something, you learn not to make that mistake, okay? But you get exposed to every facet of legal practice in such an intimate way, because you're actually making decisions and helping the judge come to judgments about the arguments people are making. And if you spend your time wisely in the courtroom, watching what the advocates are physically doing in the courtroom, it's an invaluable experience. It was not what I thought when I said no to the advice of going to becoming a law clerk. I thought it meant you were just working more in a library, and I hadn't wanted to do that. I really did not understand that it wasn't just the library work. It was a human exposure to lawyering in a way you can't receive in any other job. And most judges become part of their family. And that kind of mentorship lasts a lifetime. You can speak to that. You become a part of their family, and they become a part of your family, and it's just invaluable. Now, you have to take this from someone who became a Supreme Court justice. It's a little bit, seems false. How many mistakes could I have made? But it is something that I would counsel others to follow my advice, not my example, okay? That probably is a mistake I made. The other life mistake I made, it took me too long to realize that being open, and I think you get this from my book, that really being open to people, letting them into your life and into your feelings, is a positive thing. I spent too many years of my life closed off by my pain and my fears of pain that I really didn't get a chance to know how special people are. If you open yourself to others, and I've had this experience with my book, they reciprocate by being more open to you. I have friends for decades who, when they read my book, finally told me stories of their life that I never imagined. Hardships that they had endured, that they had stoically kept to themselves, and who, because of my openness, were able to share with me. It's been a real treasure in life. If you're in school, college, or law school, take the time not to just talk about school, but to talk about people, your friends, and their lives, and their feelings about it. It's a really wonderful learning experience. So that became my beloved world.
Well,
I did answer your question.
You did indeed. You did indeed. And your last comment actually is a good segue to my next question. When President Obama nominated you for the Supreme Court, he said that Supreme Court justices should bring empathy to the job. Although when in your confirmation hearings, you said judges apply law to facts, not feelings to facts. So I wonder if you could talk about your understanding of the role of empathy in judging.
That's such a politically latent question.
I'm sorry, I didn't mean, no. That was,
but I'm going to answer it the way I did in the book. For those of you who've read my book, you'll remember that I was a restless child. My family called me ahi, which they translated as hot pepper, because I never sat still. I can't do that almost as an adult either. So I want to roam around the room. But you will see some very official looking people in suits in some of the corners with little things in their ears. Those are my marshals. And they're here to protect me from me. They would prefer I didn't walk around you, but I'm going to do it anyway. But in return, please don't stand up in a way that frightens them. You can reach over, I'll shake your hand, I'll touch your shoulder, but if you start crowding me, they get frightened and they pull me off. So don't let them do that, okay? Or really don't make them do that. My definition of empathy, not the president's. I have never discussed this with him.
so if you're going to stand up, I think I better come join you.
I'm sorry.
I'm going to come join you as well.
my definition of empathy, and the one that I developed in my book, is can you sit yourself in the other person's shoes? Can you look at a legal problem, not from your perspective or your client's perspective, from the perspective of the other side? Every great lawyer that I have met and know does it as part of their training. They think of the best arguments their adversary can make and figures out what the best response should be. You will learn, regrettably, as you proceed in practice, that if you're a really great lawyer, you'll think of arguments they miss. That's okay. Because that really is your job, to anticipate every argument. Well, I live my life taking that a step further. I sit myself in the shoes of whomever I'm dealing with, and I try to figure out how are they feeling and what possibly could it come from. And sometimes you guess wrong, obviously, because you're not God. You can't really know what someone else's life has been like. But if you try to remember moments where you've been upset at something, and it's usually in those moments where people are really the angriest and the most combative, if you think about what motivates that in you, you can start thinking about what might have caused it in them. That, to me, is empathy. Now, that doesn't mean that you necessarily either forgive them. Some things are unforgivable. There are very few, but there are some acts by friends where it leaves you in a place that you can't regain trust, okay? But a lot of times, once you understand the motivation, it makes forgiveness that much easier. But also, you don't have to condone something someone does. But understanding it gives you a way to resolve it between you. And that's how I feel generally about the law, which is what we are doing as judges is taking competing interests in the society, represented by one party versus another, whether it's plaintiff versus defendant or state versus defendant. We're taking two competing interests, and we're using the law as a way to resolve that dispute. The law is saying one party's right, one party's wrong. Now, the people who lose in court, they don't often feel like they got a full measure of judgment, of fairness, okay? Once you lose in court, often you think the judge just got it wrong, all right? And it's hurtful. Think about it. You lose anything and you don't feel good about it. But I've learned that if you can explain to people why they've lost and what is compelling the win for the other side, it becomes an easier thing to take. And it is that empathy that, in my judgment, is necessary for judges to have in their written opinions and in the way they interact with people in any setting. So I gave an example to some law students earlier, and I'll repeat it again. There was a case a number of years back, Stafford. I think it was Stafford versus Virginia, wasn't it? The professors can tell me. Am I wrong about that? Okay. 13-year-old girl was reported, triple hearsay, to have been seen taking an aspirin. This was a no-drug school. The principal called her in, and she was strip searched without advising her parents. She brought a Fourth Amendment claim against the school, or the school board, for an unreasonable search and seizure. And the court had to decide whether that principle would apply to this kind of search in a school. During argument, the plaintiff's or petitioner's lawyer was questioned by some of my male colleagues who were asking how they could differentiate undressing in a locker room from the undressing and search that occurred in that particular case. I don't know what the lawyer said. That wasn't the important point. What was a comment that Justice Ginsburg was heard to have made after the argument. She said to some reporters, "I think that some of my male colleagues do not understand the sensitivity of 13-year-old girls with respect to their bodies." That, I don't know whether that had, and I doubt very much, that it had any impact on the court's final decision. But what I do know is that neither the majority writers or the concurrences or the dissent in that case analogize that kind of search to undressing in a locker room. If that statement had been made in a public opinion, it would have been hurtful to many, many young women. That's the value of life experiences. It's not just the conclusions we draw, but how we express ourselves and how we don't deride or diminish or demean someone else's argument in front of us. That's a judge's role, to understand, even when you're not going to agree in favor of a particular party. So that, for me, is the work of empathy.
Well, your observation about language causes me to ask who you view your audience for opinions to be.
Oh.
I think in particular of a case which was called Mohawk Industries versus Carpenters. Civil procedure case.
Civil procedure case.
A wonderful case.
Yeah.
Those of you who don't believe in civil procedure, I certainly do.
She does. It was my first opinion, by the way, for the court.
What was noteworthy, what many people noticed, is that in the case you used the phrase, instead of using the phrase illegal aliens, you used undocumented immigrants. It wasn't, that phrase didn't matter to the outcome, the issue didn't turn on that, but it did cause people to ask the question, do you view yourself as having an audience beyond lawyers, the particular lawyers in the case, or the lower court judges on that particular issue?
You know, my colleague Steve Breyer has written a book in which he says that the only currency the judiciary has in having people follow our rules of law is the currency of persuasion. That unless we persuade people in our opinions that our outcomes are just and right, they're not going to accept them as such. And so by definition, I think, every judge knows that their opinion has a wider audience than just the parties, particularly a Supreme Court opinion. Generally, we take a case because there's a circuit split, which means that there's a wider variety of people affected by our decision than just that case that we've taken. But there's lawyers, there's Congress in some situations, and there's the public in others, because we also serve in part an educational role. You read decisions like Chief Justice Roberts' decision in that veteran demonstration case, Snyder. And you understand the educational role he's doing. He spends a good part of that opinion talking to people who were going to be outraged with the outcome and explaining the value of the First Amendment to our freedom. So there are decisions where you have to do that for that power of persuasion. Ruth Bader Ginsburg, when she dissented in the Ledbetter case, who was she writing to? She wrote to Congress. And they listened, and they changed the law. That was the law that prohibited or limited the amount of recovery women could have for being discriminated against in wages. And the court took a very narrow view of how much they should be given for that injury. And Congress disagreed, and largely on the basis of Ruth Bader Ginsburg. Mohawk was written for Court of Appeals judges. It really was, that's where I had come from. It was my first opinion. And I realized that in legal practice for judges and even for the litigants before them, having a clear understanding of a rule was very, very valuable. Now, sometimes we don't write clear rules or give clear opinions because we disagree on what's clear. And lots of people blame us for that, but there are times where we understand that the way a case has been argued, it hasn't really dealt with other issues involved sufficiently for us to make informed decisions, or truly informed decisions. So it's not a bad thing when the court leaves it to the lower courts to flesh out the problems with particular legal rulings. I know that the criminal law specialists who practice the confrontation clause probably think we've done a bad area of leaving too much to the judges below.
Well, as you observe, there is sometimes disagreement within the court. That's no secret. I am curious whether there aren't occasions when you aren't tempted to just pick up the phone and say, Ruth, can we go out for a glass of wine and work this out?
With Ruth, it would probably be a cupcake or a muffin. Really a muffin. She loves muffins, okay? We do not generally, and I say generally because there's always an exception to every rule, okay? Some cases might require talk before argument, and most commonly it happens when there's a jurisdictional problem with a case. One of the justices who has read the papers will write the others and say, I'm spotting a serious jurisdictional problem, explains what it is, and then everybody gets on board on looking at it, and there's an exchange of memos about whether or not we should ask for supplemental briefing or not. And sometimes we talk about it, and the person who raised it is satisfied that the answer is no, it really doesn't exist here. But the point is that that kind of talking does occur more regularly. But there's others. There's been a few cases where that happens. But generally, we're not talking before a case. We talk first at oral argument. And occasionally, after oral argument, you'll go and say to someone, I heard the questions you were asking. What's troubling you? And there is a discussion about whether that's worthy of changing a vote or not, or why the other person thinks it's unimportant, in the hopes of influencing their ultimate vote. And sometimes even after a vote is cast, there are more discussions among people, and people have been known to change their mind in the writing. And so those discussions do continue, but it's not every case. And it's a few, it's a handful during the year.
Well, I have many more questions, but our students have questions as well. So
I know, I shouldn't go back in there too far,
well,
because otherwise these guys can't see. But
And Liz, you have the first question.
One of the nice things about asking questions, you get a picture with me. How's that? So I'll tell you why. It's a good ploy also to think a second before I answer you. So ask the question, then we'll take the picture, and then I'll answer. How's that? How's that? Ask the question.
Okay. Justice Sotomayor, you had a variety of different jobs, both as a lawyer and a judge, before becoming a justice on the Supreme Court. So I'm curious which one you think best prepared you for your current role or most informs your current role on the court.
Okay.
Thank you.
I think it's the combination of two jobs. One was a DA's office, and one was being a district court judge. One of the problems sometimes with law professors, sorry guys, is that they obviously are thinking on doctrinal levels. And that means that they have to sort of create hypotheticals that generally our cases have not answered, or that prior doctrines have not dealt with, and then sort of give their evaluation of what it means and develop it in a writing. When you're a trial lawyer and a trial judge, the doctrinal is not unimportant, but if you don't develop the facts to support the argument, no matter how good the doctrinal argument is, you're not going to win the case. And so the ability to understand how facts should be developed and how arguments can flow from the creation of those facts in the courtroom and how it can influence doctrinal outcomes, I think is what makes a really great lawyer. It's part of that practice, that empathy and that sense of knowing, how do I do this? How do I get to this outcome? What do I need to show to do that? That's what common law development of law was always about. Every fact situation, you took the facts, you gave an answer to those facts. In common law, you don't do what we tending to do more of, both on the court and in my court and other courts, which is we're sort of trying to give these doctrinal guideposts without really thinking through their consequences on the facts on the ground. And I think personally that that's dangerous. I'm a common law justice, and I tend to want to announce more simply and things based on the facts before me than a lot of my colleagues. So I think that's influenced me the most on the court.
Thank you so much.
Manny?
Oh, he memorized this question. I'm impressed. That's a lot of confidence. Okay, go ahead.
Thank you for being here tonight, Justice Sotomayor. My name is Manny Olajede. I'm currently a second-year law student here at Richmond, and I'm also from New York. So,
We have a lot in common, but you have to raise that so people can hear
right.
you right.
So my question for you is, you have been a symbol of, you have been an inspiration, a symbol of hope for many, both within the legal profession and outside of it. At what point in your life did it occur to you that your individual accomplishments and your achievements had a much greater impact on others than what you could immediately perceive or see?
Come, I'll take a picture. I have answers I've prepared in my head, but when I talk, I give more information, so I reshape my answers. During the nomination process, there are many who said that I was not intelligent enough, smart enough to be on the court. It was very, very painful to me. I had spent a lifetime of legal work making great colleagues on the Second Circuit. I thought developing a good reputation. And all of a sudden, the things I thought that people thought about me started to be proven wrong by some. The president at one point said to me, judge, because I was a judge then when I was speaking to him, just remember the press is a distortion. Everybody's going to be trying to vote for or against you, but they're never going to tell the truth. And so I try to keep that in mind, but the press was painful. And I'm very open that at one time I thought about pulling out of the process. I talked to a dear friend and said, is it worth my getting to the court with a diminished reputation? And I started to think maybe it's not. I had a very dear friend who I confided in my misgivings during this process. And she came to me and she said, she was angry at me. And she said, this is not about you. This is about my daughter. She's 8 years old, and there is no Hispanic in a high position of power in the United States of America. Your presence there will give her and many other children with similar backgrounds of different ethnicities the possibility of hope. So, yeah, you feel bad. Get over it. You know, good friends don't just say what you want to hear. They also tell you the truth as they see it. I don't know that I actually and fully believed her, but I heard her anguish at my thinking of pulling out. And so I started then to think, okay, this may not be completely about me. It got driven home after my nomination, and two incidents brought it home to me. One was walking with my staff, and there's a professor out there with her lovely daughter, Julia, who I told to go visit the FDR Memorial. I love the FDR Memorial. It's the best in DC, so I'm giving it a plug, okay? You don't pay money, so this is not fundraising. At any rate, I had heard about it, and I took my staff within a couple of months of being on the court. And I'm walking in, and this Albanian woman, I didn't know she was Albanian until she started to speak, jumped into my arms, startling the marshals all around me. They were just so, surprised as I was. Her husband's standing where the dean is standing, and he's just riveted in place. And they're both in tears. And I'm looking at them, and I'm wondering, what have I done, And the woman starts to speak, and she tells me she's an Albanian refugee, and that when she had seen my nomination process, she had grown to believe that they could make a life in this country, that someone like me could get to the position from the background I came from, which was not the same as hers, but had as many, if not many, challenges like hers, and that I gave them hope. That, I think, moment, and one similar a month after at a function where an Indian from India, native, had been serving me all night, and as I walked out, I went to hug him, and he got into tears, and he said, I have 8 daughters. I know that they can become something now. Yeah, that's when I began to know. Now, I don't fill my head with that, because if you do, it will consume you, and it can sort of make you fearful about living your life. And I don't want to do that, but I do understand what my friend tried to tell me. This is not about me. It's about something else. And so I try to continue not to live within me, but to understand that it's important for other people.
Thank you.
You're welcome. Hello.
Hello. I didn't memorize mine.
Oh, good. That's all right. I wouldn't have either, so don't worry.
I'm Holly Wilson. I'm a 3L here, and I'm from Huntington, West Virginia. My question is, there has been a lot of discussion over the years about Supreme Court clerks having a lot of influence. What role do clerks play in your chambers?
Come around. I hate to tell all those law clerks who have written about that, or former law clerks, that they're a little too full of themselves. You know, I get from my law clerks, before every argument, a sort of head count among the law clerks of who's recommending what, and the actual count never comes out the same. And meaning the justices don't follow their clerks' advice. And we have some very strong-willed justices. And so that's, I think, a sort of fallacy that has grown up. But I do think that there are some justices, and I count myself within them, who listen very carefully to what my clerks are saying. A, because they've spent this time with me in studying a legal issue. B, because they too know what our purpose is, which is to come out with the right answer under law. And 3, I hire them to keep me from making mistakes. And I often tell them, I don't want yes people. I don't need you if you're just going to yes me to death. I want you to keep me from making mistakes. And so if you disagree, keep fighting. At some point, I'll tell you to stop. But I need to be able to answer your hesitations before I can come to an answer that I know will persuade others. And so for me, I listen carefully. But do we have a 100% record? Far from it. So a lot in life is just knowledge of how the law is best served. And that comes only with the experience of having been a litigator and a judge for as long as I have. They can't substitute that. And I think that's true for all of my colleagues, which is the law clerk can't substitute that experience sufficient to be able to convince a judge on something that they don't want to do or they think is wrong.
Great, thank you.
You're welcome.
Hello, how are you?
Hi.
First of all, thank you so much for being here. It's a great privilege. My name's Cesar Ramirez. I was born in El Salvador, but I've lived here in Richmond since the year 2000. And the question I have for you is that in your book, you described the difficulty of transitioning from Cardinal Spielman High School in Bronx to Princeton University. You wrote that many of the gaps in your knowledge and your understanding were simply limits of class and cultural background, but not a lack of aptitude or of application, as you feared. So what advice would you give young students growing up in underprivileged environments to help them believe that happy endings are possible?
I spend a lot of my time in life thinking back at where my parents and grandparents started and the giant leap from where they started and I've come. It's not just, it's wider than Grand Canyon. I don't think any of them in their lifetimes would have imagined themselves or a child or grandchild of themselves ever coming to the place I have. I suspect that if you look at your parents and grandparents, that, are you in college or law school? Law school. How many of them would have ever imagined themselves being in law school? None. That's a way of keeping reality in the picture. When I was applying for jobs at the DA's office, my friends were all applying to law firms where they were making, back then, it was a rich salary, $50,000, okay? Today that's a joke, but back then it wasn't. I was going to a job, the DA's office, that made $17,500. And some of my friends were looking at me and saying, "Are you crazy? How can you give up that kind of money?" And I actually thought about it for a while because I had to ask myself that question. And I finally sat down with myself and I said, my mother would have probably given her right arm if she had earned $17,500 in any job most of her life. I was making more than she had ever made, working as a practical nurse and in her early life as a registered nurse. So sometimes you have to keep perspective and not let others define success for you in a way that's sometimes unrealistic. You know, a lot of kids go to law school thinking, oh, I'm going to be a millionaire when I go work at a law firm. I'm going to make $100,000 or more. There's a whole lot of attorneys who live very satisfying, rich lives who don't make that kind of money. We get sort of seduced by popular images of what a luxurious life should be without thinking about what the values of life are. What's important in life? What's important to you and your family? I suspect for your parents, for you to have a good job, to have a family someday, to raise children who will be good people and good citizens. You don't need a whole lot of money to accomplish those things. They've done it without a lot of money. And so I think hope is kept alive by what I call realistic expectations. Take pride on the walk you've taken and how far you've come. The road ahead seems less daunting when you know the road behind you mastered.
Thank you so much.
You're welcome. Hello. How are you guys? Can you still see me? You're not upset? All right. If you ask the next question, I'll come down to you for the picture. How's that? Hello.
Okay. Good evening, Justice. Thank you so much for being here. My name is Brittany Johnson. I'm a third-year law student here at Richmond, and I'm from Richmond, Virginia. My question is as follows. The public is very fascinated with the working relationship among Supreme Court justices. If one reads the opinion alone, it can sound very acrimonious and intense. But the justices themselves say that there's a lot of respect and friendship on the court, even among those with very different views. What has your personal experience been, and is there anything that surprised you about working with your colleagues?
They're really smart. Even the ones I disagreed with before, they're really smart. I don't take full credit for this observation, okay? Justice Souter, when I came on the court, called me and at one point said to me that he had lived more easily on the court the day that he realized that all of his colleagues were people of good faith, that they were people who did things because they too believed they were the right things to do. That insight I carried with me as I started interacting with my colleagues, and I realized that they are as passionate about the Constitution, our system of government, the law, as I am. We have differing views of what promotes our ideals. That's why we come out in differing places. But we're equally passion-filled about what the right answer should be. If you notice most of those acerbic opinions, who do they come from? Dissenters. And some majority opinions, regrettably, go too far in responding, okay? But almost all of them start out from dissenters. And if you realize that it's because they're dissenters, because they want to look at you and shake you and say, what's wrong with you that you don't see this the way I do? That gets them to the point where they get angry, some of them. That's easier to forgive. And I think all of us have found that. There have been some writings by one of my colleagues that has, on occasion, upset me greatly. We're still pretty good friends. I've been to dinner at his house. I love his wife. I still talk to him. And it's easy to say, I can do that because I won the case, so. It is somewhat important to remember that. It is really important. And we have to work together. You know, I may need his vote in the next case. And you can never forget that when you're on the court. Some courts have forgotten that. There have been some very bad relationships in prior Supreme Court bodies, in prior Supreme Court years. But I think that this more modern court has a greater appreciation of the institutional need to work together. People forget how many unanimous decisions we come out with. Last year we were at a bit of a low, but the year before that we were at 64%. It's pretty high. And we've been high in other years as well. So sometimes it just depends on the take of the issues that we've accepted. But in a good number of our cases, we are doing what we all think as a unanimous body is the best answer to a legal question.
Thank you so
You're
much.
welcome. Okay. Hello. I'm going to come next to you. How's that? Ask your question so I can hear it.
Well, good afternoon, and thank you for joining us today.
You're welcome.
My name is Brent Ashley. I'm a 2L, and I'm from Delaware. I was also a 2010 United States Sun Youth Program alumnus. We met then.
Oh, okay. You seem familiar to me.
Yeah.
So.
My question is, if you were a framer and knowing what we know now, are there any structural changes you would make to the court, and would you have specified more about the court in the Constitution?
I probably would have told the framers that Congress could not specify our standards of review. I personally think that judicial independence is compromised when Congress decides cases by specifying with the detail that it's grown to do what the standards of review should be of a court. EPA is one of them. We are now in a place where a clearly constitutional wrong, or clear enough so that people who look at it say, this isn't the right answer, will still be upheld because EPA tells us that if it's not an unreasonably wrong answer, it's okay. Try explaining that to somebody in jail. And I think try explaining that to the founding fathers, who I think might have had a very different view of what justice is about. And I mean, equal justice for all is on your state capitol building. There was much more, I think, respect for law as law by the founding fathers. And I think we've gone too far in the direction of a statutory civil system than a common law system. I mean, our standards of review in the courts have been developed through decades, if not centuries, of dealing with an issue and understanding what best review standard gives meaning to that standard of justice. And when Congress changes it, it does so without that experience. And so that's what I might do. If you want to change the Constitution generally, read Justice Stevens' recent book, where I think he gives 6 or 8 suggestions for amendments to the Constitution. Some of them I agree with, some I don't. That's a subject of an entire class. But I think you should read it so you start thinking about it. and start considering which ones make sense to you as citizens and which don't. Good luck.
Thank you very much.
Shriek.
Good evening. Thank you for being here. This is truly a treat. My name is Sharika Banks. I'm a third-year student here at the University of Richmond, and I am from Richmond, Virginia. My question to you is, you are the first and still the only woman of color on the Supreme Court. On one hand, you have a great opportunity that no one like you has ever had before. On the other hand, there's a lot riding on your shoulders, and sometimes it must feel like you are not an individual but a symbol. Do you feel a sense of special responsibility in deliberating?
If the import of your question is, do I feel that I have to rule in a certain way because I'm a symbol of something? No. And I don't, because I hope that what I'm a symbol of is that people respect that I do what I think is right under the law. And if I lose that, then I lose my own sense of self-respect. People who have read my jurisprudence know that I support death penalty convictions all the time. Doesn't mean that I think every conviction has followed the rule of law. And when it hasn't, I speak out about it because I think it's the thing you have to do. But it can't be confused with my being a advocate for criminal defendants, which some people have labeled me, and I go, how about all those cases where I vote against defendants? You just conveniently put those under the rug. I think that's what people do. And if you start playing to their expectations, I fear I would lose who I am. And I'm not about to try to do that, okay? I do think, however, and this was a gift from someone who I greatly admired, Connie Baker Motley, who you'll hear a lot about in the coming year. She was on Thurgood Marshall's legal team. She was one of its most influential women. She won something like, 9, 10, 11 Supreme Court cases? She lost only one then. 20 years or 30 years later, the Supreme Court overruled that loss, so she won all of them. All right? She was the first African-American woman borough president in the Bronx, that was my old hometown. It's a tough venue, okay? She was, and still is, a role model to me. And one day, she looked at me and she said, when we were discussing whether I should do a particular job or not, she looked at me and she said, you have no choice. To those of us who think whose blessings are given, you have an obligation to give them back. You just can't sit back and not do a job because you don't want to do it. If it's an important piece of work and it's a work you can do, you do it. Well, I've lived with that responsibility of giving back. That's why I come to law schools and I speak to all of you. That's why I go to community centers and other venues that some justices don't. I've been to medical schools and I've talked to doctors. I've been to deaf grammar school, schools of middle schools with deaf children. It was the loudest conversation I've ever had. Their fingers were clicking so loud, it was just an amazing conversation. I have met with senior citizens, the homeless, with people of all backgrounds and all experiences in life, in an attempt to do a little bit of what I'm doing here, to educate them about the law and to talk to them about its importance in their life. And that's my giving back. And yes, do I feel a responsibility to do that? Absolutely. I think that I've been blessed with so many things in life that to whatever extent I can in the role that I'm serving right now, help spread it, inspire someone else to go out and change the world, to make our world a better place, then that's a role I have to fulfill.
Thank you.
You're welcome.
Hello.
Hi, ask your question. I'm roaming up and coming back down.
Hi, my name is Cassie Powell, and I am in my final year of a dual degree program here, and I'm from Yorktown,
Of the what
Virginia.
degree program?
A dual degree program.
What are you studying?
I'm getting my law degree and my master's in social work.
Wow.
I usually tell people I'm a 4L, but people are confused, so. So here's my question.
You just don't want to give up school, right?
That's really what's going
Okay.
on. Brown versus Board of Education was arguably a leading indicator of social change, and that school segregation was widespread at the time and continued for some 20 years afterwards. In contrast, Obergefell v. Hodges might be seen as a trailing indicator of social change, and that acceptance of marriage equality had become very widespread very quickly in the years before the case. Do you think that the Supreme Court has a particular role to play in social change movements? A leader, a follower, or maybe something else?
None of those things.
So something else?
It's something, yeah. You know, we've led in some areas. Racial integration was one of them, probably the most well-known. But think about the other areas of social movement, okay? Women voting. Oops, sorry, I'm looking at the wrong camera. The court was so behind the society in terms of women's equality that it's almost painful to read the court's decisions. 1960s, 1970s, the court is still saying that states can exclude women on juries because they had young children. The court is still saying that bars can exclude women from membership if they choose. The court, in terms of women's suffrage, didn't have a voice at all. That was a popular campaign by women that got women the right to vote. And in terms of equality of women for opportunity and things like that, it's all popular will. It wasn't until Sandra Day O'Connor and Justice Ginsburg together came on the court in the 1990s, way after the equal rights movement and other things, that we had the court actually rendering one decision that favored women in the Virginia military school case. Okay? So you can't talk about the court as a leader there. Absent DOMA, think of some same-sex marriage or even gay right equality case. Has the court ruled in favor of any of those? Right, okay. If we get too far ahead of society, our opinions won't be valued or followed. If we fall too far behind society, then we suffer the reverse consequence. We become inconsequential. And people begin to think that the court serves no useful purpose in the society. I don't think it means that we have to think about or should think about how our opinions will be received as outcome determinative to what answers we should reach. But there is nothing wrong in seeing how opinions will be received and trying to explain them in a way that people can understand them. I think that's the Snyder case I spoke about earlier. And there are others the court has written where that's been the case. We are members of this society. We move with it. We grow with it. I mean, Brown versus Board of Education was premised on decades of experiences with separate but equal that proved that it just wasn't the principle that was ever going to work. That was really the holding of Brown, that, we said separate but equal was constitutional, but we can't achieve separate but equal. So we've got to go back to its original 14th Amendment meaning, equality. I don't see the court serving as that agent purposely. I think sometimes we become it because of the nature of our rulings, particularly when real constitutional rights are at issue. But I don't think it's what the court thinks of itself as. And I actually don't think that it's what people should perceive us as. It's always a working endeavor between popular will and the society changing and us moving with it.
Thank you.
You're welcome.
And one final question.
Good evening, Justice. My name is Kathy Liu. I'm a third-year law student here, and I'm originally from Houston, Texas.
Go ahead.
My question for you is, as a Supreme Court Justice, the cases you hear are typically involve polarizing or controversial issues. As can be expected with that, there are often those who are going to criticize your viewpoint on these cases. How do you usually handle such situations, and what would your advice be for young lawyers when faced with similar criticism from their own peers or mentors?
And it'll happen.
Sorry. Oh, you're done, my bad.
If you're a judge or a justice, you really have to have a fundamental belief in the rule of law. And that fundamental belief guides you not just in doing things that might be unpopular, but that you think are right, but doing things that others think are wrong, coming to answers that others think you're crazy about. But because you have a belief in this system, in this rule of law system, you understand that many unpopular beliefs will grow popular with time, that some unpopular outcomes will be undone by the Congress or the population itself. And it's that keeps you sort of making what you think are the right decisions, even if they're not admired. And you almost have to do that as a lawyer. Think of all the lawyers who have been persecuted, some of them almost driven out of their hometowns because they've represented unpopular people, whether it's terrorists or others who have supported causes that others don't believe in. Why do they do it? They do it because they really do believe in this rule of law. They really believe that everyone's entitled to a defense. And if you can keep that fundamental belief in your practice, it will help you withstand those things. That's the only way that you'll do things like that, is if you actually believe that the system has a purpose, and that it's a valuable one, and that you play a valuable role in maintaining it. Good luck in doing that.
All right. Justice, thank you so much. It's been a wonderful, wonderful conversation.
I've had so much fun with all of you. I think we have a little bit of time left. Oh, we did. We didn't go that much over. For a reception, and I'm looking forward to seeing many of you there. Okay? See you soon.
Please join me in thanking the judges.
Thank you.
We'll go this way.